Dear students, greetings of the day. In this video, we will learn about the Insolvency and Bankruptcy Code 2016, in short, the IBC. You all must have heard that in 2016, the Parliament of India enacted the Insolvency and Bankruptcy Code 2016. It was all over the news that the IBC has brought with it a paradigm-shifting framework for insolvency laws. But did you know that IBC is not the first legislation regarding insolvency enacted in India? In fact, India has had a long history of insolvency laws dating back to the 1800s. What is the history of insolvency laws in India? Why was the IBC introduced in the first place? What were the problems with the erstwhile insolvency laws that ushered in the need for the IBC? These are some of the questions that we shall explore in this video. First, we shall look at the history of insolvency laws in India. Let us trace back into history of insolvency laws in our country prior to the enactment of the IBC. Prior to the time when British came to India, there were no insolvency laws in our country. With their intention of engaging in trade with Indians, the situations of payment and repayment arose in India, which at times led to default during repayment. This was the reason that necessitated the need to introduce insolvency laws in India. Now, the first insolvency legislation in India was the Statute of 1828. Under this statute, an insolvency court was established in the presidency towns of Bombay, Madras, and Calcutta. Next, in line with the laws in England, the Indian Insolvency Act of 1848 was passed in India with the primary objective of resolution and settlement of disputes of insolvent debtors. Eventually, the high courts as well as the district courts were empowered with handling insolvency matters. To address the issues arising out of the inadequacy of the Indian Insolvency Act of 1848 and to further improve the Act, the Presidency Towns Insolvency Act 1909 was passed in India for the insolvency in the Presidency Towns. This statute regulated the insolvency of individuals. There was an official receiver to be appointed under this legislation in whom the property of the insolvents would be vested. Now, for the rest of the India, other than the presidency towns, the Provincial Insolvency Act 1920 was enacted. Thereafter, in 1956, we had the Companies Act 1956. This was the first legislation with a comprehensive framework for the winding up of companies. Section 243 of this Act laid down the grounds for making an application for winding up. Section 433 set out the circumstances for winding up. And Section 488 set out provisions for voluntary winding up of any company. Moving on, in 1985, a new enactment by the name of SICA, that is, Sikh Industrial Companies Special Provisions Act 1985 was introduced. This act applied to public and private industrial undertakings. It looked into the situation of industrial sickness of these undertakings with a view to revive and rehabilitate them. In accordance with the recommendations of the Tandon Committee, the Rai Committee and the Tiwari Committee, this act was brought into force. In terms of Section 310, an industrial company was a company which had been in existence for a period of 5 years or more with a net worth of either zero or in the negative. Once this sickness of an undertaking was determined, remedial measures were taken for expeditious enforcement of the Act to revive and rehabilitate such a company. The basis for bringing an action under SICA was the undertaking's inability to pay. an application was required to be made before the Board for Industrial and Financial Reconstruction, that is the BIFR, for adjudication of a matter with respect to the sickness of an industrial undertaking in the presence of the company as well as its creditors. The appeal lay before the Appellate Authority for Industrial and Financial Reconstruction, that is the AAIFR. This was about the SICA. However, the Sikh Industrial Companies Special Provisions Act 1985 could not be successful in terms of its implementation. So, by the recommendations of the Goswami Committee, the issues in SICA were identified. In 2003, the Sikh Industrial Companies Special Provisions Act 2003 was passed to repeal SICA, and the provisions with respect to revival and rehabilitation were incorporated instead in Part 6A of the Companies Act 1956. This repeal act came into force in 2016. The Goswami Committee made other recommendations as well. In terms of their recommendations, the Recovery of Debts Due to Banks and Financial Institutions Act 1993, that is the RDDBFI Act, was introduced. This act set out a mechanism for banks and financial institutions only to make an application to the Debt Recovery Tribunal, that is the DRT. It set out under the act to obtain a certificate of recovery from the DRT in respect of the defaulting debtor. Recently in 2019, this act was renamed to the Recovery of Debts and Bankruptcy Act 1993. This act is still in force. Next, in 2002, we had the SARFAESI Act, that is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. This SARFAESI Act provided for a mechanism of expediting recovery and defaulting debtors without approaching any court or adjudicatory authority. This legislation allowed banks and financial institutions to recover their non-performing assets, that is, their NPAs, and sell the secured assets of the defaulting debtors. Lastly, we had the very famous Companies Act 2013. The Companies Act 2013 provided a comprehensive framework for winding up under Chapter 10, revival and rehabilitation of sick companies under Chapter 9, as well as provisions for voluntary winding up. Presently, by the introduction of the IBC, there have been amendments to the provisions of the Companies Act 2013. This Companies Act 2013, as per its section 465, repeals the previous Companies Act, that is, the Companies Act 1956, except a few provisions. Finally, now we come to the Insolvency and Bankruptcy Code 2016. In the year 2014, the Ministry of Finance instituted the Bankruptcy Legislative Reforms Committee. This was led by Mr. T.K. Vishwanathan. In its report, it set out the need for a single and comprehensive framework of insolvency laws and recommended a bill for regulating insolvency, which came to be adopted as the Insolvency and Bankruptcy Code 2016. By introduction of the IBC, the Presidency Towns Insolvency Act 1909 and the Provincial Town Insolvency Act 1920 were repealed, and individual insolvency as well as insolvency of partnership firms was governed under the garb of the IBC itself. This was all about the history of insolvency laws in India. Now let us explore the problems in these legislations which ushered in the need for the IBC. Now, Like I told you, even though there were legislations governing insolvency, there were many concerns with the erstwhile legislations which led to the introduction of the IBC as a single and comprehensive legislation. Let us explore these one by one. The Goswami Committee identified that Section 22 of the SICA 1985, which set out the provisions for moratorium, was being misused by the promoters of companies, and it was becoming a situation of rewarding inefficient and irresponsible entrepreneurs. Further, the reliefs were not long-lasting, as the entities would anyway dissolve eventually. There were a lot of delay in sanctioning of the schemes, and the BIFR as well as AAIFR were not empowered adequately to handle the cases. Eventually, SICA was repealed. Now, in respect of the RDD-BFI Act and the SARFAESI Act, the concern was that these acts had a limited scope of application, and they provided relief only to banks and financial institutions. Further, the DRT and the DRAT under the RDD-BFI Act were not empowered to assist in the rehabilitation or dissolution of defaulting entities. Therefore, they could not function as an effective forum. They could only assist by issuing a certificate of recovery. In cases that were pending before the BIFR, the DRT could not assist in any manner whatsoever. Hence, the situation of debt recovery could not be improved under the RDD-BFI Act. The situations did improve to a certain extent under the SARFAESI Act. This was because under the SARFAESI Act, recovery was possible without court intervention. However, it was only applicable against those debts which were secured by secured assets. The legislation lacked any authority empowered to consider restructuring and reorganizing alternatives. It established a parallel institution, causing confusion as well as issues such as forum shopping. These two enactments, that is RDD-BFI Act and the SARFAESI Act, are still subsisting in the regime of insolvency laws in India. Please remember that the RDD-BFI Act has been renamed and is now called the Recovery of Debts and Bankruptcy Act 1993. Finally, while the new Companies Act 2013 replaced the erstwhile Companies Act 1956, yet the legislation applied only to companies. There was a need to have a single consolidated law which would set out the insolvency regulation for individuals and partnership firms as well. Because of all these issues and concerns, there was the need for the introduction of the IBC, which provides a single comprehensive framework for governing matters of insolvency under one umbrella legislation. So students, I hope through this video it is clear to you as to why there was a need for the introduction of the IBC in India. Hope you enjoyed it and learnt a lot with me today. See you again in the next video. Till then, stay tuned and keep learning.